Okay, so ready to go deep on law.
Always ready to dive into the legal world.
You brought us this Wikipedia article on it, and wow, it's a lot.
Yeah, it covers centuries of legal thought.
It really does. History, philosophy, different legal systems from all over. It's dense.
Dense but fascinating. Think of this deep dive as like a crash course on the ideas that have shaped laws for millennia.
Exactly. We're hitting the highlights, the big aha moments.
Yeah.
And it all starts with a deceptively simple question, don't you think? What is law?
You'd think that'd be an easy one to answer, right?
You really would. But this article, yeah, it jumps right into the philosophical debate.
Because there isn't one universally agreed upon definition, is there? And that's where jurisprudence comes in legal philosophy.
Okay, so break that down for me.
So jurisprudence, it looks at the nature of law itself. And the article makes this distinction between two main approaches: analytic jurisprudence and normative jurisprudence.
Analytic versus normative. Okay, those are some big words. What's the difference?
Think of it this way. Analytic jurisprudence is about what law is objectively like, describing its structure and how it works.
Okay, so like the nuts and bolts.
Exactly. Now, normative jurisprudence, that's about what law should be, its moral and ethical dimensions.
So is it good? Is it fair? Those sorts of things.
Precisely. It's about the goals and values that law should promote, like when we debate things like freedom of speech or the right to privacy.
Got it. So analytic is like, here's the law, what does it say? And normative is like, okay, but should it say that?
You got it. And this tension between what law is and what it should be is a constant theme in legal thought. This article highlights some of those big thinkers.
It really does. And there are some real gems in there. Like that one definition from Oliver Wendell Holmes Jr. He said something like, law is basically just predicting what courts will do.
Ah, Holmes always cutting to the chase. He was all about the practical side of law. It's not just abstract principles, right? It's about real-world outcomes.
Decisions made by judges, juries, all based on the specifics of the case.
Exactly. And those decisions, well, they create a kind of roadmap for how the law is understood and applied.
Speaking of roadmaps, this article takes us way back to the origins of law. And I mean way back.
To ancient civilizations and their legal codes.
It's amazing to see how long humans have been trying to create order through law. Like Hammurabi's code, talk about old school.
Almost 4,000 years old. Older than the pyramids.
Seriously. Okay, so what was so special about this Hammurabi guy? Did he invent law or something?
Not quite. But his code was incredibly influential. It covered everything from trade and commerce to family matters and even criminal justice.
Wow, so they had like a rule for everything.
Pretty much. And get this, they made multiple copies of the code carved into stone and displayed them publicly.
Talk about making sure everyone's literally on the same page. No excuses for not knowing the law right.
Exactly. It was all about transparency and establishing a common standard of justice. And then we can fast forward to ancient Greece. They had this interesting distinction between nomos and themos.
Nomos and themis. Okay, I'm going to need a translation here.
Nomos referred to human law, the rules and customs created by people. Themis, on the other hand, referred to divine law principles believed to be handed down by the gods.
So that age-old question, do our laws come from us, or are they given by some higher power?
Exactly. And it's a question that still resonates today, don't you think?
Totally. Do we create laws based on what we believe is right or wrong, or are we trying to follow some kind of universal moral code?
Right. Is it about reflecting our values, or is there a sense that law has its own power and logic that exists outside of us?
Lots to ponder there. And speaking of systems, we can't forget about the Roman Empire and its lasting impact on law.
The Romans, they were masters of organization right, and their legal system was no exception. The article mentions the Corpus Juris Civilis, a massive compilation of Roman law ordered by Emperor Justinian.
So like a greatest hits album of Roman law.
Exactly. It brought together centuries of legal thinking, and it became a model for legal systems across Europe and even beyond.
Talk about a lasting legacy. But of course, legal systems have evolved over time, and today we have different types like common law and civil law that we hear about all the time.
Different branches of the same tree, in a way, each with its own distinct history and approach, but ultimately grappling with the same fundamental questions about justice, order, and how we govern ourselves.
I will dive into those different systems in more detail right after the break. Okay, so we're back and ready to untangle these different legal systems.
It's like a global legal sampler platter, right?
Exactly. We've got civil law, common law, religious law. Where do we even begin?
Well, we touched on civil law earlier. Those Roman roots run deep.
Right. It all starts with those ancient codes.
Exactly. Civil law is all about having a clear, written set of laws. That's the ideal in a comprehensive legal code that covers pretty much everything.
So it's like, here's the rule book. No surprises.
Exactly. And it's the most common legal system in the world today.
Really? More than common law.
Oh, yeah, by far. It's the system used in most of Europe, Latin America, Asia, Africa, huge parts of the world.
So if civil law is all about the code, what's the judge's role? Do they even have any wiggle room to interpret things?
They do. They're not just robots, although some people might imagine it that way.
Right. They're not just looking things up in a giant legal dictionary.
Exactly. Judges in civil law systems, they still have to apply those written laws to the specific facts of each case. And sometimes those laws are open to interpretation. So yeah, they have a lot of power.
Okay, that makes sense. So it's not as rigid as it might seem at first.
Exactly. Now, common law, that's a different beast altogether.
Right. This is where things get very British.
Yeah.
It's all about tradition and precedent. Right?
Yeah. Picture this. Medieval England, traveling judges going from town to town.
Okay, so like a legal roadshow?
Exactly. And instead of having one big law book, they're looking back at past cases, past decisions to guide them.
Ah, so that's where precedent comes in those landmark cases that set the standard.
You got it. They were building the law organically, case by case, decision by decision.
And what about the Magna Carta? It always comes up when we talk about common law. What makes it so special?
Well, for starters, it's old. We're talking 1215.
Okay, old for sure.
Yeah.
But what did it actually do?
Well, it established this really important principle that even the king is subject to the law.
Whoa, so even the guy at the very top has to follow the rules.
Exactly.
Yeah.
That was a radical idea at the time, and it really helped to establish the idea of a more powerful, independent judiciary.
No more king's whims deciding everything. The law is the law.
Exactly. And that emphasis on precedent and a strong judiciary, that's the foundation of common law. And it's still the system used in many countries today, including the U.S.
It's amazing how those medieval traditions are still shaping legal systems today. But it does make you wonder, if common law is so reliant on precedent, what happens when there's a totally new situation? Something that those old cases couldn't have even imagined.
You're hitting on a key point there, and that's where the idea of equity comes in.
Equity. So it's like common law's cooler, more flexible cousin.
Something like that. Equity developed alongside common law to address those situations where the strict application of precedent might lead to an unfair result.
So it's like a legal loophole.
Not exactly a loophole, more like a safety valve.
Yeah.
It operated on principles of fairness and justice, and it allowed courts to provide remedies in situations where the common law felt too rigid.
So it's about finding that balance between predictability and fairness.
Exactly. And you know what's really interesting? One of the things that came out of those early courts of equity, trusts.
Trusts, like the kind we use today for managing money and inheritance and stuff.
Exactly. The whole concept of a trust, where one person holds property for the benefit of someone else, it has its roots in those courts of equity.
Wow, I never knew that. Okay, so we've covered civil law with its focus on codes and common law with its reliance on precedent. But there's another big category out there, right? Religious law.
Right. And this one highlights just how diverse legal systems can be.
Because for some cultures, law and faith are inseparable.
Exactly. And we're not talking about some small niche systems here. We're talking about halakha in Judaism, Sharia in Islam, canon law in Christianity. These are systems that have governed societies for centuries.
So in these systems, the law is seen as coming directly from a divine authority. It's not just about what humans think is right or wrong.
Exactly. And that raises some really interesting questions about interpretation and evolution. How do you apply these ancient texts to modern-day situations? It's a constant process of interpretation and adaptation.
It's amazing to me how many different approaches there are to law. And we've just scratched the surface, haven't we? All right, time for the final act of our legal adventure. We've talked about the philosophy, the history, the different systems, but how does it all actually work in practice?
Right. It's like we've been studying different types of cars, and now it's time for a test drive. Let's see how these legal machines perform on the open road.
I love it. And there's no better place to start than criminal law. Right. It's the stuff of headlines, TV dramas. Always captivating.
Absolutely. It's about the rules we set for the most serious offenses, the things that can land you in big trouble with society.
Exactly. But how does the law actually decide what makes something a crime? Where do we draw that line?
Well, the article talks about these two key concepts, actus reus and mens rea. Latin, of course.
Because this would be law without a little Latin, right?
Exactly, but they actually represent pretty simple ideas. Actus reus basically means guilty act. It's the actual doing of something that's prohibited.
Okay, so if I steal something, that stealing is the actus reus.
Exactly. But here's the thing. It's not enough to just do something bad. There also has to be mens rea, a guilty mind.
Oh, interesting. So, like, I need to have intended to steal the thing. If I just accidentally walked off with someone's bag, that's different.
You got it. It's about intent. Did you mean to commit the crime? Of course, there are some exceptions, like in cases of negligence or strict liability, but generally both act and intent need to be there.
Makes sense. Now, you mentioned exceptions. This article talks about this crazy case from the 1800s, R.V. Dudley and Stevens. Shipwrecked sailors, a lifeboat, and, well, a truly impossible choice.
Yeah, that case is a classic example of how murky things can get. 4 sailors, lost at sea, no food or water for days. They're desperate. And ultimately, they make the decision to kill and eat the cabin boy, a young man who was already very weak and close to death.
Oh, my gosh. That's just unimaginable. So they're rescued.
Yeah.
What, they try to claim they were just trying to survive?
Exactly. That's where the whole concept of necessity as a defense comes into play. Can you ever justify breaking the law, even taking a life to save your own?
That's such a heavy question. What did the court decide?
They convicted them of murder. The court said that even in extreme circumstances like that, necessity can't be used as a defense for murder.
Wow. It really shows that the law doesn't always have easy answers, does it? Sometimes it has to grapple with these impossible moral dilemmas.
Exactly. And that's what makes it so fascinating. All right, ready to lighten the mood a bit. Let's talk about something a little less, well, life or death. Property law.
Okay, yeah, sure. Property law. It seems pretty straightforward, right? What's mine is mine, what's yours is yours.
You'd think so, but it gets surprisingly complex. I mean, what does it even mean to own something?
Okay, yeah, when you put it that way.
Right. And this article highlights a case from 1722, Armory v. Delimery. It involves a chimney sweep who finds a jewel.
A chimney sweep. Now that's a story.
Right. He finds this jewel and takes it to a goldsmith to get it appraised. But the goldsmith, or actually his apprentice, tries to cheat the chimney sweep out of it.
Oh, no. Did he get his jewel back?
He did. And the case established this important legal principle. Possession is 9/10 of the law. Well, even if you don't technically own something, if you have it in your possession, you have certain rights. You can't just be cheated out of it.
So finders keepers really is a thing.
To a certain extent. The court said the chimney sweep had a right to keep the jewel until the rightful owner came forward. Of course, property law has gotten a lot more complex since the 1700s.
I bet, especially in our digital age, right? You own your online data. What about virtual property in the metaverse? So many new questions.
Exactly. But those early cases, they still laid the groundwork for how we think about property and ownership today. Okay, ready for our last stop on the legal tour?
Hit me.
International law, the Wild West of the legal world.
Huh. Why do you call it that?
Well, think about it. We've been talking about laws within countries, right? But what happens when you have multiple countries, each with their own laws, trying to interact with each other?
Okay, yeah, good point. It's like everyone's speaking a different legal language. How do you even begin to create order out of that?
It's a challenge, that's for sure. And one of the biggest issues in international law is enforcement. See, there's no global police force out there.
Wait, really? No one to keep those countries in line?
Nope. It's all based on countries agreeing to cooperate, to follow certain rules and treaties.
So it's basically a giant game of trust.
Kind of. There are international organizations like the United Nations that try to foster cooperation and resolve disputes, but ultimately it depends on countries acting in good faith.
It sounds incredibly complex, especially in today's world, with so many global challenges that require countries to work together.
Exactly. Climate change, international trade, human rights. International law is more important than ever, but it's also facing more challenges than ever.
It makes you appreciate that law isn't just some dusty old subject, right? It's a living, breathing thing that's constantly evolving as the world changes.
Absolutely. And we've only scratched the surface. There's so much more to explore, different legal traditions, emerging areas of law, the ongoing debate about justice and fairness. It never ends.
Well, one thing's for sure. This deep dive has given me a whole new appreciation for the law, how it shapes our lives, and how much more there is to learn. To our listeners, I hope you feel the same way. And remember, law isn't just for lawyers. It's for all of us.